excited about this. We've got a great panel here. We have what should be a very interesting discussion, a pretty exciting ballot initiative. So just to get started, to introduce everyone, I probably recognize some of these people. Professor Lothar at the end teaches here, as well as I think at Hastings on by these companies in Silicon Valley, but also teaches on computer law, internet privacy, data privacy. Similarly with Professor Hoofnagle here, teaches law school and at the high school, similar subjects. And then we have Ms. Mary Ross, who is the president of Californians for Consumer Privacy, which is the organization behind this ballot initiative we're here to discuss today. Before that, she worked in DC in the House of Representatives on the Committee for Intelligence, right? And before that, the CIA. So, very interesting background. I'm sure she's got some insights. So, just to get started, I think we should kind of frame the issue here. So, let's start with you, Mary, and just kind of what is the issue that this initiative is trying to address? Like, what's the problem here? Go ahead.
Well, first of all, thanks for organizing, and it's timely.
And just let everyone know this is being recorded right now too, just for everyone to notice. Okay?
For your privacy.
Yeah, privacy.
So what our initiative is designed to address is kind of the expectation gap between what you think is being collected and then what is actually being collected. And then to give consumers more control over their personal information and the spread from a first party that you give it to third parties. So the way that we set up the initiative, it's three different parts. So the first part is a right to know. So if it passes, all Californians will have the right to find out what personal information a corporation is collecting about you and about your devices and also about your children. And it's set up there's a list of categories that you can find out if they're collecting. The second part is a right to opt out of the sale of that personal information. So if a business is selling your personal information, they have to tell you, again, by category, what they're selling. They have to tell you to whom they're selling it. And then they have to give you the right to tell them, no, I don't want my personal information sold. And then the last piece of it is a data security piece. So current California law says that if a company collects personal information and certain categories of personal information, they have to implement reasonable security practices to safeguard that personal information. And so what we did is put that into our law and said, if a company fails to do that and there's a breach, it's a violation of our initiative. And the reason why that's important is we have a private right of action in there, which also says that any violation of the act itself is injury in fact.
Thank you. Just as a heads up, if anyone has any questions, feel free to interject. If you hear something, follow up. Thank you, Mary. And then kind of just for filler for people who aren't from California, what is a ballot initiative?
Sure.
Why did you choose to go through a ballot initiative rather than just the state legislature?
So in California, in theory, any resident of the state of California can propose an initiative. And there's two types. There's statutory and constitutional. So ours is statutory. So if it passes, it'll become part of the Code of California. And then if you collect enough signatures, which is in the phase that we're in now, then it gets put on the ballot for all Californians to vote. And then if it passes, then it becomes law.
And so is there a reason why you did an initiative rather than trying to go through?
So I like to look back at last year's session of AB 375, which was, it was going to say that when the FCC, when their regulations around what internet service providers could sell, when that was rolled back by the Trump administration, Assemblymember Chow tried to introduce something similar for California. It was very popular. It was triple referred, which meant it had to go through 3 different committees, which is impossible hurdles, but it passed all those. And then in the middle of the night, AT&T had every lobbyist they have on their staff go and lobby members to kill it. So it was literally killed in the middle of the night. So I think this is exactly why we have the initiative initiative process in California is that something like this that is so pro-consumer, but yet legislators are reluctant to turn their blind eye to the money interest behind them.
You mentioned a couple things I think we could follow up on, particularly these categories of information. What does that cover? Why did you guys choose to pick those things?
So we decided to go by categories for two reasons. One, if you were getting all of the information back that you ever either uploaded or that they collected about you, you could just simply be overwhelmed in information. And so the interesting pieces might be lost in thousands and thousands of pages of information back. Also, we didn't want to open somebody up to the threat of identity theft if they were getting back your social security number. So what we decided to do is we have a list of categories that includes things like your geolocation or health information or biometric information or psychometric profiles. And so they have to report back if they've collected that information and if they've sold it. But we also have a provision in there where every year the Attorney General has to add categories. He's not allowed, or she is not allowed to take categories away. But we imagine that that list will expand as time goes by as technology continues.
Then the other thing I thought was interesting is this being a pro-consumer initiative, the opt-out versus the opt-in requirement. Why default with the opt-out rather than default you have to opt-in?
All right, that I'm going to let Chris show that question. we started with an opt-in, but then we listened to wiser minds.
Over a year ago, your team contacted me to talk about what a ballot initiative might look like in California for privacy. And one of the in the drafting period, one of the things I noticed was that it was affirmative consent. And of course, there's the whole series of growing case law. It seems to be becoming even more powerful that companies have a free speech right, and there's a real risk that the protections be declared unconstitutional if opt-in is applied to non-sensitive information. So I think you can apply opt-in against sensitive information. So like your credit report is protected by opt-in protections, and so on. But outside that, your initiative would cover information that's going to be in the public record in some contexts. It's going to be a real challenge to deal with this First Amendment problems, and that's just one of them. There's other kind of First Amendment problems nested in
Well, and also just the way it's an opt-out. So the way that we wrote it, it's pretty prescriptive. So any page where a company is collecting personal information, there has to be a button. Similarly, like there's a link to a privacy policy, but it has to be a standalone button that says, "Do not sell my personal information." And if you press that button, and they're not allowed to say, "Oh, well, your service is going to slow down," or "You're not going to be able to have access to certain features." If we have an anti-discrimination provision in there that says, like, should you choose to opt out of the sale of your personal information, they're not allowed to charge you a higher price or deny you access to service. And we also made it so that a third party can opt out on your behalf. So that we envision, because there's a whole industry of data brokers and other businesses that are collecting your personal information that you might not even know exists. So we imagine that a third party would come along and start
That'd be like service it's offered. So the company would go ahead and opt out.
or like just like how the Electronic Frontier Foundation has Privacy Badger as an ad blocker.
And then just kind of getting towards the scope, we talked about the categories covered, but who is this going to apply to? Just anyone that collects data? Or?
So the way we define business, it's any how you would imagine a sole proprietor or corporation that has over $50 million a year in annual gross revenue, or that sells 100,000 records of individual consumers or devices per year, or that gets 50% of their revenue from the sale of personal information. And so the groups we're trying to cover are either really big businesses, so like Google, Facebook, Apple, or data brokers.
And then, Chris, you touched on this, how some of this information would be publicly available, but then reading through the language also wouldn't cover information that's been de-identified.
Mm-hmm.
So can you kind of explain where that falls in there, or?
So by definition, de-identified is no longer personal information. So we wanted to just kind of draw that line there so that, you know, if there's, for example, for research, that you could still share. Actually, backing up a little bit, our definition of sell is to sell for consideration. So how you would think of, I give you $1, or to share for a third party's commercial purposes. And so there, it's the what we were trying to get after are all the tracking pixels that you might have heard about more in the Zuckerberg testimony. But right now, on every web page, it's Facebook. When you see that Facebook share button, it's actually a tracking pixel. So you don't necessarily have to have a Facebook account, and you don't have to even interact with the button, and they're still tracking you. And so there, we wanted to make the opt-out effective, so that if you say don't sell my personal information, that also means you can't allow a third party to access what I'm doing online through this tracking system.
And then if we could turn to Lothar for a second, our industry guy here. It's November 7th, and the initiative gets passed. What do you tell your clients the next day? What are they going to have to do, and how are they going to have to comply with this? What sort of issues are they likely to face?
So I'd be happy to cover more than just the industry view and be the industry guy, but I can start with that if you want me to. Like from a company perspective, if I'm a European company, I would say this is going to level the playing field a little bit. The US has been ahead in technological development of the Europeans probably 5 to 10 years. This is when I came to the Silicon Valley. This was already the case. I think the gap has widened because of the restrictive data protection laws, regulation of data, rather than protecting and focusing on individual privacy, just prohibiting everything, creating all kinds of paperwork, and this assault on free service models where people don't have to pay for interesting services that have developed over time, but then can benefit from them, and the companies can monetize this with advertising financing. So from a European perspective, I would say that's a good move here, because these companies will be severely hit, will possibly have to start charging for their services, and therefore level playing field. I like it. As a US company, if I have a business model established, or I want to establish one that is not charging for service or products, then this is going to be a big hit to the business model. I think.
Just to be clear, though, we do allow advertising
Yes, you
as
do.
one of the businesses.
I just say what I tell my clients, not necessarily what you tell your clients. But the fact that I have to make all this information available free of charge, I can't discriminate based on people opting out, basically means that I will probably have to stop offering the service that way. I have to charge for services. And I think a lot of services that exist would never have been developed if these advertising models hadn't existed and weren't permitted to. In Europe, where I still teach at the Free University, there's a bunch of startup companies, but they have a real hard time to get funding when everything they do is prohibited. When here in the US, you start developing this, you get really large, and even though everything is prohibited in Europe, you still have now such a power as when you go there that you can sell those services here. I don't think we would have maps, and we wouldn't have social media, virtual worlds, all this stuff wouldn't exist. I don't think we would have self-driving cars. At least they wouldn't be very safe if I have to give privacy notice and access and people can opt out and stuff. I think it would just throw everything very much behind. So that's what I would tell my
And also,
clients.
to be clear, we allow collection in the initiative. So we say that you, Tesla, who's still developing your self-driving car, or Uber, you can collect as much information as you want to about me. You can use it however you want to. but if I ask you what you've collected on me, you do have to tell me that. And if you want to transfer it to a third party that I don't even, or I may not even know exists, you have to give me that right.
I wonder, Josh, if you would entertain me trying to say a little more than the business view, because I had to criticize Mary. We only met her for 15 minutes, and I didn't get to say anything positive because I was looking at it from the industry side. So if you entertain me, I grabbed a bunch of hats because I wear other hats in my day-to-day life. You notice I teach. So as a law professor here at Berkeley, I'm really proud of what Mary does, and she raises a really interesting topic here, puts it in the public discussion. I get to hang out with Chris, who I rarely see anymore because we teach at the same hour, and I think this is a good thing. I was in Washington, D.C. I was meeting with the Data Protection Authority in Japan last week, and when I meet with the European parliamentarian in charge of the privacy directive update and with the mother of the GDPR, if you will, and I always tell them California has pretty strict rules, and I'm proud of it, and I think we're very innovative here, and we have new ideas, and that you raise this attention as a law professor, I think is a great thing, and I'm thankful for this, and I was very appreciative also that Josh invited me here to the meeting. Now, as an author of California privacy law, I'm super excited because this book has only 550 pages, and Mary here, by not repealing anything and just adding a whole bunch of things, will make this twice as big. I don't know if that's good. I don't get paid for writing the book, actually. The IPP makes all the money, but I'm excited to contribute, and Chris actually encouraged me to write this book in the first place, and now he introduces me to somebody who makes it even bigger and more interesting. So I'd say that is those two hats. As a lawyer, I have mixed feelings about it. Actually, that is my California consumer hat. This is some kind of Canadian supplier to the legal industry. So as a lawyer, right now I get to talk 100% of my time, actually 120% of my time right now, only about European GDPR. I go to Japan GDPR. Next week I'm in India every day. The clients have requested that I talk about GDPR. And there'll be a lot of extra work if I get to talk about this California initiative in the future. Everybody has to do business here. It's not like they can leave California or not sell to the 39 million people that live here. I would say after 10 years, maybe we'll be down to 32 million because some of the companies will have to move eventually, and the industry will probably be significantly affected here. But initially, there'll be a lot more work to do, and I might retire in 10 years anyhow. So as a lawyer, I'd say this is also great stuff. And when I was explaining this in Washington, I hadn't done my homework, and I love to make up facts. So I just said, I think there's a conspiracy from some plaintiffs' lawyers. I only saw the name of the law firm you listed, and I didn't know that Mary works for the CIA, an organization that never lets anybody go. So I have full new conspiracy theories. But before I get to them, I wanted to say very briefly what I feel as a consumer. And this is my Escape from Alcatraz, a great event that I recommend you all do. It's a must, especially for my LLM students while they're here. As a consumer, I say when I came here, I always use Google Maps. I love this service. I love it on my bicycle. I use it walking. It directs me all the time. I've never paid a penny for it. And I remember, I'm not an early adopter of all technologies. I'm actually getting a little old there myself. You mentioned children. My kids are so much smarter and quicker with things than I am now. But I remember when the BlackBerry came on the market and when it added maps, that really changed my life. And I love this. And I still do. And I'd say this service would not exist if these free models wouldn't exist. And I have a Toyota Prius 2007, which my son will have to drive next year. And he's not in favor of this. He wants a sports car or something, but he will get that car. And it has the original navigation system that doesn't find half the places anymore. And it would cost me about $500 to update it every year. And once we have self-driving cars and so on, we really need to have access to these modern services. I think my forecast for the Europeans, I wrote an editorial for one of the privacy papers there on my short version of my new paper, No One Owns Data, in German, and I point out that this idea to create data ownership rights now to somewhat support the car industry, I think it is going completely in the wrong direction. And I think the preservation of free service against over-regulation of data protection is really what I think is necessary. And so I think as a consumer, I'm not happy about if this passes, and I would strongly encourage everybody to vote against it, because it will be an onslaught against this free services model. I don't see the point. You're writing in here, you're kind of scaring people about companies, and we have the nice visuals here, which looks more like a CIA agent than somebody working in one of the nice startup companies that I work for. But I'm not scared. I don't see the harm proposition. The two things you raise in the letter here that resonate with me, one is discrimination and one is data security breaches. And I'm so proud when I go around and promote California privacy law that we addressed those relatively early and relatively well. We have very good discrimination on unfair competition laws. We have much more enforcement on that than we have in Europe. And we dealt with data security breaches in a really good way, namely not punishing the victims of these breaches for suffering a breach, but to make them report it, and then people have to show harm and standing and so on to have a successful litigation experience out of this. And most of the time they don't have any harm. I've had my social security number lost by the University of California Berkeley School of Law 3 times. And some guy once tried to get a mobile phone account on my behalf, and I complained, and I'm nearly done. And then you get to defend yourself against the consumers too, that I represent here for a second. That's not normally what I do.
Well, you're a very unusual consumer.
I had this one identity theft situation. I've helped some individuals in my circle of friends that suffered this, but I think California has addressed that. And all these other things that you have in here with free access and reports and companies can't charge it, it's just going to socialize the cost for all of us, because the free services will have to change. The companies will have to charge for it. They won't be able to innovate. And I think that really shouldn't happen in California.
Yeah, but I think, well, so for one, we approach this that privacy shouldn't be something that only the law can do. 2, privacy is something that's protected in our Constitution. It was established in 1972. We have a constitutional right to privacy. I don't think that making companies be transparent about what they are collecting is going to change their ability to innovate. That just doesn't make sense to me. And if it does, then I think I better go run something. Yes.
So I guess I want to ask a question to bring that all together. I feel like there are clearly a ton of stakeholders in this matter. And so I'm curious, as someone who's helping to draft the ballot measure, who's actually in the room, and what perspectives you're taking into account as you create the actual language. So do you have someone from a tech company in the room? Or
Yes,
do you
so
have anyone?
we absolutely did. We hired Ashkan Sultani, who is the former chief technologist at the FTC, and he did a lot of work on the do not track language. So you'll see a lot of that's in here. We sat down with Facebook and with Google and with Apple and with Microsoft. Nobody would play with us and send us language, but actually Apple was probably the most helpful, and so there's a whole list of business purposes that isn't selling. So for example, for fraud detection or advertising is one of them. I can still pay with my eyeballs for these free services. You have to tell me if you're collecting information.
Because I guess one thing I'm curious about is the actual technical implementation of this for a tech company. If it's like such a high bar, then there's no way that they will adopt it. So I'm curious how you kind of find that.
Well, I mean, if it passes, they have to adopt it. It'll become a law.
Sure.
And we did things like they have 9 months to come into compliance with the law. And then the Attorney General has quite a bit of authority to change this regulation depending on what kind of technology changes. So for example, like one of the things that we require is that if you say, I want to know what you've collected on me, you have to submit a verifiable request. And so that's one thing that we let the Attorney General define, is how do you make your request.
I tried to give some context. I used to be on the board of Catalog Choice, which did let people opt out of catalogs, and not really for privacy. It was for environmental reasons. There's a very interesting series of problems that arose from this, and they're kind of informed by the ballot measure. So the idea with catalog choices is that you tell them, opt me out of all these catalogs. I don't want them anymore because of the environmental damage. It's interesting. Many companies just wouldn't accept. They'd say, no, this we want to see a power of attorney. We want to, we won't recognize a Comcast, for instance, would categorically not recognize this delegated opt-out. So one of the ideas behind this is that organizations like EFF could even have a membership level where they charge you $100 a year, and they would take care of the kind of the opt-out mechanism, and they would figure out the kind of techniques of doing that. It's interesting what happened with catalog choice. They became so dominant that the data brokers themselves recognize the catalog choice feed. So Experian and whatnot have a suppression list built around catalog choice. So you could see a similar thing here, where someday there's suppression on a kind of technical and business level integrated into the field.
And there are some companies. There's some companies now. Like there's one called AV that has the two different services. One is Blur, which is a password, one password type of, and one is called Delete Me. And so they're all about trying to protect your privacy online. And so they're very excited.
If I could return to a point that you brought up, Lothar, I mean, one of the interesting things that happens in privacy legislation is that no serious piece of privacy legislation has passed since the 90s, probably the early 90s. Yeah, like.
You don't read my book. I gave you a free copy.
Okay, on the federal level. And part of what's happened is a kind of complete obstinance from the industry to compromise or to even negotiate. So if you look back at California SB 1, this is what creates privacy protections for your banking records here in California. The industry wanted no opt. They wanted to make it so banks could sell, like quite literally, how much money you have in your checking account to anyone they wanted, and you wouldn't have any right to opt out. And their experts went to the Hill and whatnot and said, we have a First Amendment right to sell your social security number and all your banking information. And so the only way that kind of position could be dealt with was with a kind of ballot initiative. It's like the legislatures were so captured by the banks, the only way they could kind of go at it was with this type of measure. But I wonder, like, in a larger sense, you started out with the European Union. Could this trigger kind of a nationwide strategy on data privacy? Like, could we start getting to a place where we could start talking about adequacy and other things that the Europeans want to see out of our continent?
It's an interesting question. So Paul Schwartz, who teaches privacy here at Berkeley, actually, he wrote an interesting paper, Privacy and Preemption. So there is hope after this passes on November 8th. There will be federal law preempting this, I guess, if that's where you were getting at. I think there would be definitely a move to doing just that, because California would have such radically different rules than the rest of the country that there would be an initiative to somehow overrule it and make it a more legislative process, right? If this goes through with the ballot here, then it goes through just like we can't shoot mountain lions anymore in California. We have them coming out of the wood and eating all the deer, which I personally really dislike, and the authority.
Car emission standards that every other state, the car companies have to comply with to do business in California, and I would argue that is a good thing for our country.
That's going away too, if I read the lead, and I'm totally for emission control, for sure. I'm in favor of that one.
Total back.
I hope that's not the impression I'm giving. It's just all these hats. That's kind of confusing who I am to you, right? To address Chris's question. So first of all, I think there's a strong likelihood that there would be something happening federally, which may be a good thing, and that's why I said early on. I think bringing up this discussion, getting people to focus, talk about it. Where is the harm? I think is an important part, because there's so much venting going on, so much anger. It's good to talk about it and do something about it, and you guys are doing something. So I think that's the positive part. I think in the legislation here itself, it would meet a lot of the European requirements. I mean, it sounds a little bit like you borrowed from the General Data Protection Regulation in there. And I think some companies might welcome, even in the US, some harmonization, say then we have level playing field and so on. But it doesn't address everything. You have only the larger companies, as you said, or the brokers who are prohibited anyhow in Europe. And I'm not sure that this would get us much extra points from the EU with adequacy. We already have an adequacy program where the Commerce Department of the United States lends its great website capabilities to allow people to sign up for Privacy Shield, and the FTC lends its enforcement apparatus to it. And so I'm not sure that the Europeans would look at this and say, oh, now we're giving you adequacy. partly because this is also a trade measure for them, like the GDPR and its predecessor, the Directive 9546 EC. Remember, that was at a time when the European Community had just changed the name from European Economic Community to EC, and this was a trade measure to have privacy law harmonized. This wasn't about privacy. The Commission couldn't care less about whether privacy is here or here. They just want a level playing field within Europe, and they wanted to use that to have the trade bloc with 500 million or so consumers to be have a power to negotiate deals with the rest of the world by putting this Article 25, 26 in the directive now in the 40s that you have to completely refrain from transferring data to other countries, which they're now using very effectively to negotiate with Japan, with Singapore on adequacy. That's why there's such great interest in the European law. And I think they're using it with the US, but they have not much to gain by giving us this adequacy. So my answer on that one is we'd have to succumb to all of the demands, like putting a data protection authority in place and all this bureaucracy and paperwork that has worked so well to suppress technological development in Europe, that I think the price is too high, and I don't see how America would succumb to that, just get this adequacy. So that's my answer to that, Chris. I don't see that happening. I would see a federal law. I think a federal law with preemption, as Paul noted in his article in the Yale Law Review, would be welcomed by many companies in the US because it would level the playing field. And as a practicing privacy lawyer, you wouldn't have to read 50 books like this with different state-by-state diverging statutes, Nevada security law, Illinois biometrics, and so on. It would get easier to practice. It would ossify as well. A federal law, even in Europe, gets changed only every 40 years or so. And so the same thing would happen here as well. Once there is federal preemption, that's probably how it's going to be for a long time. And last point, just on we have no significant privacy laws. I think there hasn't been that much for the good reasons that Paul described in his article. There hasn't really been a need identified. There isn't this great harm that is being in very abstract points and with impressive graphics, but without really good examples on where all this discrimination happens. Most of these privacy lawsuits, they fail because there's lack of standing, because there's no harm to prove.
Okay,
And
I'll give you an example. So your Fitbit is actually collecting lots of health information. When your doctor's office says, oh, download MyFitnessPal and hook it up to your Fitbit, and I can measure, I can see as your doctor, I can see what your heartbeat is, I can see if you're doing the exercises I told you to do, you're putting in what you're eating, I can monitor and help you and let you decide if you're making healthy choices. What you don't realize is that there's an app that's in between Fitbit and your doctor's office that's actually out there scraping all that health information and then selling it to an insurance company who may not offer you insurance or may offer you a different price for insurance, and you have no idea and no remedy.
I have no idea because I don't think that's going on right now. I've not read about that. I've heard this as a conspiracy theory, but I've not seen an insurance company doing that. And I think if that's the harm you're talking about, then let's regulate insurance companies and prohibit them from doing this discrimination if we think individual tariffs are not fine. Some people
But
think...
right now there's no way to find out what is being collected and who is collecting it. So this first piece,
Yeah, but
the right to know.
the collection doesn't hurt me. I don't care. My watch is a little more
It's
traditional
your-
than yours. I like actually Fitbit and some of the other fitness trackers too. The smartphone does it now. I don't see the harm. How is this harming me? And if we don't like individual tariffs, insurance tariffs, and there's pros and cons. I have one of my doctorate students in Berlin is writing about whether there should be individual tariffs. There's already some individualization in terms of bad drivers. Once they had an accident, they have to pay more. Why not look at aggressive drivers and charge them a little bit more upfront the way they're driving? Probably moot because it'll be all autonomous cars soon, but there are pros and cons. It's a different discussion. And the mistake the Europeans made, they regulate data processing, prohibit it. They should protect privacy. They should protect against this discrimination. And we can come up with a lot of conspiracy theories. Your agency, the CIA, has never hurt me. It protects me. It does its good job. It probably has killed some people abroad, and I understand that they're unhappy with the national security. But the whole NSA scandal, I don't get it. I also don't get it that we're blaming who our president is right now on some social media, or the Russians buying ads on social media companies. Is that really who we are as a country, that is our problem? that we have to now pin this on somebody else. Let them micro-target me as a voter and tell me what I really care about. I don't see the harm in any of this. If you have this problem with the insurance company, regulate the insurance companies. And I think what you're describing would already not be allowed under insurance law, but it's a little bit outside my specialty.
But then what is the issue with transparency? If you're collecting information, what is wrong with requiring a company to tell me what they're collecting so that I can be that watchdog and make sure that...
I think they already have a company that provides an online service under California Online Privacy Protection Act already now has to tell people what they do with the data. And if they don't do it, they get sued by the same people that's supporting these ballot measures and they pay a lot of money.
No, it's the way the law is currently written, it doesn't do that. Shine the light, they only have to...
That's a different law, but the California Online Privacy Protection Act of 2004 requires a provider of online service to say what data they can collect and who they share with. They have to disclose this if they give it to insurance companies.
They don't have to tell what they're collecting about you. And the other
No, they
loophole
do.
that they've gone about is they don't have to tell what you're collecting on your device. Right now, my phone
They
goes,
absolutely have to tell you because it's an online service directed to consumer. And then we have the
But what about
Confidentiality of
offline?
Medical Information Act that probably also applies to this. It's already there. These are laws that are 10 years old, 14.
And what about your brick and mortar stores? So when you're walking around these things and they're collecting information about you,
That is true that the online brick and mortar stores, if they don't provide an online service, which many of them do now, they're subject to this. But guess what? In California, we have the Beverly Law. It's a super new one, so you might not have heard of it. It's from the 70s. It was updated in 91. And it prohibits anybody in a merchant business who collects personal information from somebody who pays with a credit card. They can't collect anything from you, and they can't share it with anyone. And you're right that a lot of companies fail that law, and there's been so much litigation that the class action plaintiffs' lawyers don't even have time to focus on everything that's going on websites because they make so much money out of these settlements. But this is an old law. It's already addressed. There's no need to have this additional transparency that you're creating here. What you have here with all these individual access requests, deletion, opt-out, is a direct hit on any free service model, and it will prevent the companies from being able to offer this free service because they won't
but
get
how
the
if
revenue
you can
anymore.
still advertise? That's a revenue stream.
I mean, you have these opt-out rights in here,
But
so
you're not allowed to opt out of advertising.
So can you flesh that out a little bit, Mary? If I opt out of Facebook or Google from selling my data, how would they still monetize?
Well,
that?
Google and Facebook say they don't sell personal data. So technically, they shouldn't even be covered under this. Other than what I mentioned before, the tracking pixels that are only there to spy on you when you're going about your business on the internet. Then that would be prohibited if you opt out of the sale.
So, but if I do opt out of the sale, how would a company be able to advertise? still
Because we
monetize?
have specific categories of business purposes that are not considered selling under our law.
It still is the case that most websites make most of their revenue from the contextual advertising, not behavioral. So that would be the kind of distinction, the technical distinction here, where the contextual advertising continues unabated, but more behavioral types would be restrained by those who opt out.
So is that like when you search something online, maybe you start seeing ads for that? Is that what you mean by behavioral, which is contextual? I'm just trying to.
So behavioral is your click stream over time, versus contextual is you're on the website of New York Times, you get ads related to kind of what we think the demographics of a New York Times user are. It's interesting if you look at the economics of it. A lot of everyone is working on behavioral advertising, but most of the money is still made in contextual.
Great.
So I have a question for both of you. You talked about harm, and I'm curious, you also talked about how the law will say that violation is an injury in fact. In light of the Spokio decision, which said that still can't go past the standing Article 3, how do you expect to deal with that? And then my question for you is, why should any demonstrable harm be necessary in the first place? Why is a violation of a legal right not enough? Sort of like a dignitary harm. If we say, we as a society think this is wrong, why shouldn't a violation of that be enough?
Well, in looking at Spokio, I think that's part of the reason why we changed the standard in this law. So that if you're collecting information on me, and not telling me what you're collecting, or if you're selling my personal information, even though I told you not to sell my personal information, that is a harm to me. And I shouldn't necessarily have to prove that I had suffered monetary damages, or those things are so intangible and so hard to prove that what we're saying is privacy in itself is something that should be preserved.
So my answer would be, first of all, that's not new that we don't have a standing requirement in California. We don't. So we have lots of laws where you can enforce just the legal right. And the reason why this is being opposed and actually ratcheted back a little bit is the abuse that in litigation occurred. There's one case I'm mentioning in the book here on this on Beverly Law, where a judge got so fed up how these things are settled. They always settled that plaintiff's lawyer walks away with $1 million or so, and the defendant had to spend a couple of million on doing discovery and so on. And the named plaintiffs each get $1,000 or so, 3 or 4 people, and the class gets some coupons. And so in this one case, it was against a lingerie retailer, and the plaintiff's attorney was male, and the judge proposed in the settlement agreement that he be paid his attorney's fees in $10 coupons off of lingerie. And this was such a serious offense in California that judge was off the bench and doesn't have a job anymore, just proposing that in the settlement agreement, which surprised me. I always read the discipline reports where the attorneys caught like the 8th time stealing from the client and being recovering drug addict and whatnot, and they're suspended for 3 days or so. But that judge was off the bench. So there's a big monetary interest. You see Wall Street Journal and others were just reporting some scams where lawyers and doctors are working together on some shady scheme to talk people into having certain operations so you can bring a lawsuit against medical device providers. There's just a lot of abuse in the legal community, and I'm part of it. I'm a member of the State Bar.
Yeah, but there's also some.
I just want to say that the standing requirement, that one of the reasons why we require harm is that we want to only bother our courts when there's a real case of controversy. Everything else should be resolved on a policy level. And I don't think money is the right remedy, or litigation would necessarily be, in this case, brought by an individual if that individual is not harmed. Here in your paper, not only in your proposal, not only do you allow with the class action lawsuits and so on, you also want every agency in the country to be able to challenge the constitutionality of any steps against in the state of California.
So you're telling me that you don't think the Attorney General should be able to bring suit on behalf of the citizens?
I didn't think that individual plaintiffs' lawyers should do that. Government enforcement is a different thing. And when we're talking about Europe, how those laws there work, there's no private enforcement. There's practically zero. But if you introduce these rules here, then the plaintiffs' bar will have a feast. And that is now concerned to you Berkeley students, because you're in the best school in the country, the best IP program in the whole world, technology program. Go Berkeley Technology Center for Law and Technology, so you don't worry about it. But they'll be, all the other law schools will be doing really well after this, because our profession will bloom, because there'll be so much work to do to bring private enforcement. I just don't think that's appropriate if there's not a harm to individuals. That should be done on a regulatory basis. I'm okay with the Attorney General bringing these suits, but not every agency in the state of California. There's so many agencies.
Where I think you're wrong. I'm not a trial attorney, and yes, I think there's many abuses in the system, but the corporations are obviously abusing the system as well. I think currently, as we've just seen with 2 days of testimony from Zuckerberg, where he didn't say anything except political apologies.
For the record, I totally disagree with that, but I'm not going to comment on that one.
Charles, I think
But look at the changes in smoking regulation. That was the conversation.
But there was harm. People died of lung cancer. Was there harm in this?
Well, I'm telling you that I feel like just seeing how much personal information companies are collecting without telling you, there is harm there. And you're wrong about the discrimination. There's a case with Steve Woods where they were showing people advertisements based on how far away you were, based on your IP address, to a competitor's store. And so what ended up happening is that lower income people were shown higher prices because they were further away from, or they were further away from the competitors.
Let me say one thing on this. We want to probably take questions too, but just on that one. I'm from a little village in Germany. I grew up with 5,000 people in the village. Everybody knew everyone. And our local merchant also knew who we can charge a little more and a little less. And I think the internet is becoming that, and it's becoming that for people who like to disclose a lot about themselves and want to be in communities. I'm not sure about this one case. I didn't read up on that exactly. I think there are initiatives where the internet companies or online retailers are trying to develop more of a relationship. They want to understand exactly what they're dealing with, and I think they will
Okay, and
start.
what about employment discrimination?
I'm
Because
just
you're only
acknowledging-
showing your advertisements to 18 to 25-year-olds, and you're being ageist. Is that okay?
I want to actually address it, and I'm actually making one point in your favor here. I think there will be price discrimination. Some companies will do that, and I think the airlines are already doing this. If you and I book a flight and we sit next to each other, we'll probably pay differently based on what they think, what I'm going to pay, and how urgently you need to go to the place. I think there will actually be some of that harm. You didn't call it out specifically. I think that is going on. I think those practices are, from an ethics perspective, a little bit questionable. And I think companies will be challenged on it. There will be unfair competition lawsuits, but the law is already out there. If you charge people wrong prices, you mentioned there is litigation over your case.
Okay, what about for-profit universities that are only showing advertisements to low-income minority women because they know higher-income people aren't going to click on it, and in addition, they want you to apply for a federal loan?
Well, so what I'm trying to say is this is not anything new. This already happened, at least in my village.
Yeah, and
this
it's
was
going to
normal.
keep on happening unless we
But
get
then let's
greater
regulate-
transparency
but-
and accountability.
But then let's shut down all these bad online universities. If they're bad, I don't know. Let's take action on pricing. If we think that people shouldn't be negotiating prices anymore, you seem to favor a lot of regulatory hardcore European approaches. In Germany, it used to be prohibited to negotiate prices, and you couldn't do rebates, and this was all super regulated. Then regulate pricing if that's the thing. And if you think that Staples has to show the same ads to everyone, then let's do that. I don't see the harm in the privacy piece. You can give me these examples, but I think the harm that you're describing is already regulated. It's unfair competition. Employment discrimination is not a new sector, and I don't think your law is going to do anything
But
about that.
why is asking for greater transparency, why is that such an undue burden on a business? That's where I don't see.
On the disclosure requirement, what data you have, that's the least of the concerns here. I think that's already mostly out there. I gave you the examples of the California Online Privacy Protection Act. That's from 2004. It does that. You were making the point about the retailers. I told you the retailers can't even collect anything under the Beverly Law. So I don't think there is that much left. But yeah, if that was the only thing in here, and that might be the federal law that will preempt this if it gets passed, it would be a disclosure. I also wouldn't have a problem with that. I think every company could do that. They already have to do it now under the European law. The information will be out there. That's probably not a big deal. The transparency part is not what concerns me. But we were
Let's try to get
probably
some
missing
questions.
Chris.
Okay, yeah. So I sort of have a long spiel here. 2 questions, 1 concern, and a comment. So I'll start with the concern.
Take notes here.
I'm just afraid that this law would provide or would create so many compliance costs that it would deter entry from smaller startups that might be able to compete with, the Amazons, the Facebooks, the dominant players in these online ecosystems. And then the comment would be, I'm not as worried about the one, store in a German village. I'm worried about one entity controlling every store in every village and price discriminating on that basis. And, not having the ability for another store to open because they need access to a certain amount of data to provide that service. And then the question would be, haven't read the law recently, so could you remind me what are the damages stipulated for private parties? Is it civil penalties? Like, how would we establish what the actual damages are? if companies just don't comply. And then one more thing. And then given all of the laws in California that actually already apply to consumer privacy, why is the California Attorney General Office's Privacy Enforcement and Protection Unit only 3 attorneys? And how would we make sure that these laws are actually enforced, so it's more than actually just a ballot initiative that gets passed, but actually has some teeth and some enforcement? Since I know that the Cal AG can sue under the UCL and get $2,500 for each violation of the law.
So it's the way it's written, and I don't have the number on top, but it's per, yeah, I don't think, it's per violation, so I think it's $1,000 per violation. And then and then to answer your question, that's why we need a private, it's $1,000 are actual damages, whichever is greater for each violation from the business or person responsible. And then to
And
answer
3,000.
if there's if and not more than 3,000 are actual damages, whichever is greater for each violation of the business or person responsible if the business is knowing and if there's a knowing and willful violation. And so just to answer your question though about the AG's office, that's also why we have a private right of action.
The interesting thing about the AG is that there have been so few cases, and we could ask why. My understanding is that they don't think they have as much clear authority as what the statute seems to suggest. So they think they're underpowered, and of course there's kind of a political economy problem as well, where many AGs want to ultimately run for governor, and I think this has caused some of them to not to be pretty deferential to Silicon Valley.
I'd say also one of the reasons is that the FTC has been doing a pretty good job. Chris has this excellent book, which when I was just in Japan, actually they're translating into Japanese, and they already know, and you're a very revered privacy expert there and here. So the FTC is taking care of that, and then there is all this privacy enforcement that we have here. So the California AG only gets involved if they see something that is not already taken care of by private enforcement. And those are the guys that will go after the 1,000 to 3,000 per violation, which adds up to billions of dollars. Now, on the data access question, you're concerned that the big companies get this. I think the big companies will be keeping the platform even more tied up because of the pressure they're getting under privacy law. I think one of the things why there has been a lot of sharing is antitrust concerns that if you lock up the platform too much, then there would be challenges. And so they've been sharing a little more, maybe that they now hear they should have, and this is being locked up more. I think that will hurt more of the smaller companies that will go into this field. And the cost of putting all these restrictions on us will be very differently effective. I mean, you mentioned a fitness tracker, and I don't think, I've never heard that particular scenario, so I don't want to endorse that in any way. But if that were going on, this kind of monetization, first of all, I think they would have to disclose it, but these fitness trackers also, they come at a fairly low price, I think. The device is relatively cheap, the service forever free, and so on. The companies would have to change these business models. And when you said earlier that you don't want only the rich people to have privacy, and they're certainly the ones that are fighting for this, and I was hoping you'd tell us a little bit about the gentleman who sponsors the whole initiative. It's typically the billionaires and the Trumps of the world that are really excited about ratcheting up privacy laws here because it's good for censorship and for
entirely not
protection.
true.
Not in your case, I don't know anything. So tell us a little bit about why this one businessman is interested in this.
So I haven't actually read this law. However, I wanted to go back to Florida's disagreement, and I'm hearing information that seems to be coming from different courthouse territorial differences. Because, for example, within the U.S., like one price discrimination that currently goes on is if I want home insurance or insurance in general, if my zip code is 94598, I've literally been told because of my zip code, I'm automatically getting a 10% discount. However, coming back to Berkeley, I've noticed a 20% increase, but that's because I'm wealthy enough to move locations and collect the data for myself. So even in a real world price discrimination game, there is real harms being done to people in that if you do not have certain wealth access, you would not even notice this pattern happening in the first place. So I don't really agree with what's been said about that there is no difference between the small village in Germany where we kind of have price personalization versus in this larger technological gambit. In this technological architecture, there's a big difference between where human nuance and human decision regulation starts entering. In the German market situation, sure, there's feedback. There's human feedback within the village community. Whereas in this situation, there is a big difference in that where would that feedback occur if you don't know? There is no village equivalence. There's no way to see that someone else got treated differently. So so I want to hear a little bit more of like, because like I feel like that wasn't really concluded. Like I feel like what does transparency mean to different? That's my question, because to me it seems pretty obvious we need the transparency as the first step to be able to determine what the regulation is, and without that first step, we wouldn't even have the German village that knows each other to be able to know that the German market was doing price personalization, to then be able to give feedback and go, I'm okay, I'm not okay with this.
And we agree with you 100%. And that's why the first place where we started when we were drafting this initiative is the right to know. If a company can just keep in darkness what they're collecting, they might as well collect everything because there's no price associated with the retention and collection of that information. And so, yes, like that first piece is finding out what's being collected, but then we're running a political campaign and it's want to give consumers the choice to say, okay, like I'm deciding to do business with you. I'm deciding to send that e-bite, or I'm deciding to use Facebook. I'm not consenting, and I don't even know if all like the axioms, all the data brokers are sitting there and also using that access point as a way to spy on me and do who knows what with that information.
I just wanted to make the point on this. The transparency is kind of, we're using it in different terms, right? One is I was very transparent where I lived and people knew everything about me. And I can now choose on the internet whether I want to disclose things or not. But the point I was making more is if you think this price discrimination should be prohibited, I don't know that privacy is really our angle here. Then let's prohibit price discrimination. Say everybody must be charged the same things and no negotiation.
Price discrimination should be eliminated. I wasn't even implying. I'm sorry if I implied that was not what I sought to imply. I was also pointing out before you can even make a decision on the regulation of price discrimination, how are people getting involved if there wasn't transparency for them to know in the first place?
So on the transparency point, I mean, that's the one where I don't have much of an issue. If we wanted the companies to disclose more, I kind of think that our laws already do that. Maybe not as elegantly as a GDPR would do, or a federal law that just says everybody has to disclose. But that's what the FTC's been saying for a long time. There's been enforcement too. I think every company should disclose what personal data they have. You mentioned Axiom again. I hate to say something about a company because they're probably a client of a firm somewhere. But I think you can go on a website, I did this once, what my data or something, and you can look what they have on you. I think that's a good practice. They did this voluntarily, they didn't have to. I don't have a problem with that part.
They don't have to show you everything there.
They say they do.
Yeah, and I don't
You
trust
have
them.
conspiracy theorists. This because you worked at the CIA.
So,
But tell us a little bit about the person that sponsors this.
Great, I wanted to hear
I'll just say that I actually think you don't have much choice in sharing information with companies. The techniques to discover people's identity are very subtle and complex. I actually worked on a whole bunch of those Song Beverly cases. And if you look at kind of the history of Song Beverly, the idea was to make credit card sales as private as cash. That was the premise. So the idea was if you went and pulled out your American Express, you wouldn't you could pay without creating a kind of dossier of your purchases. And so what retailers did was they want to know who you are. So they started out by asking people's home addresses, and there was a period of time where you get a printout from the register that said, put your address in. And that was pretty obvious, and there were cases about that. And then they went to phone numbers. And the idea there was that they could take those phone numbers to a data broker and then figure out your home address. And then in the kind of third phase of deception was simply to ask you your zip code. So ask you your zip code. There's only one Lothar Determann in the zip code of, what side?
Atherton's
Atherton.
very small.
Atherton. And so then I have your home address. And from there, we've gone to even more complex ways where non-personal information is being used to re-identify people in real space. So I don't think it's consensual, and I don't think people know about it. And so the big kind of lie now is we don't sell your information. What they sell are de-identified hashes of things like your phone number. It's not personal information, it's a hash. But then they can send that to Axiom or Experian, and they can reverse the hash and say, oh, well, that's Chris. The FTC hasn't taken a case on, and we haven't been able to kind of create a public dialogue around it.
I mean, there was Senator Rockefeller sent letters that I had to answer for some clients asking about data brokers and what they do, and the FTC actually had guidelines, and I've heard the term a couple of times from you. There was some pressure on this industry, and nothing was done. My guess is because there wasn't that much harm yet that they could prove. The examples are far in between. I see that people are
buying lists of rape victims or home addresses of police officers. That's okay.
rape victims, police officers.
Yes,
You're going
Pam
into
Dixon showed that in her testimony before the Senate Commerce Committee, which is what you wrote letters to, that you can go to a data broker and buy a list of rape victims so that you can market that.
I think that's a good example of a practice that should be prohibited. But what Chris was saying, where the retailer asked me what my zip code is to decide whether they should open a store a little closer to me.
That's not what you're saying, though. But I'm sorry, I don't know if I implied that. What they're doing is they're figuring out your home address so they can create a unique view of you as a consumer. So basically what's happening is
the harm? I want them to do that because, for example, my favorite beer brand, they don't have it in my local Safeway anymore. But they have it here on the one on Claremont and College Avenue, so I go there sometimes before class when I beat the traffic, and they always look at me like I'm a complete drunk because I buy like 6 bottles of my favorite beer. They have it there, and I can park there because it's early in the morning. They should know what I'm interested in. I'm cool with that. How does this
stopping
mean?
that. We agree with you.
No, so Beverly actually makes it a little hard for them.
So I'll bring you that beer from now on. Tell me what it is, and
I left it in the car. I'll show you.
But that's why we say collection of information is fine. If you want to use it to change what you're offering in that store. Okay.
It's kind of the larger, issue there is the kind of online profiling is filtering into the offline world, and in ways that are, I think, straight up deceptive. I mean, including by
Good, then
companies.
it's already prohibited. Deceptive practice is already prohibited. I don't think we have a disagreement on it. But we don't need this law for that. That's already prohibited. Right?
Alright,
Chris,
I think we're gonna have
your
to
whole
wrap
book
that
says
up,
that.
so- Or if we have one more question, let's just.
One thing. I'm very European when it comes to data privacy and with you in this question. I was wondering, looking at Ballot, and so what we have as a right is the right to know and then the right to opt out specifically from selling. How do we as consumers really benefit from that? So whether I know what someone has on me, if I cannot prevent them to have that data on me, it doesn't really help me, but for making me more paranoid. And then if I can prevent them from selling but not prevent them from doing anything else, that is there a risk that it opens a new door of just creating a back door of selling, as for example creating algorithms that you already think that you need them in-house, and then instead of selling the data, you sell semi-created algorithm, and then you're kind of making the loop around the rule.
Oh, and so look, first of all, this is the first step. Right now, having that transparency will probably change behaviors, and then also it'll probably change the behaviors of companies. So for example, Facebook, if you don't have an account with them and you say, what do you know about me, and they're sending back a ton of information, that's going to change behavior. eBite is a data broker. So they're, I have little kids, I get them every week, and they're selling things like the presence of children in household, and they're selling if you're an alcohol enthusiast. and they're selling.
My
your-
family's been brewing beer for 195 years. It's widely known.
And they're selling your religion. And so if you you see an advertisement, you're paying with your eyeballs, you don't expect them to be selling all this information on top. And if they have to disclose that clearly, it will probably change the company's behavior as well.
I would like to ask one question of Mary, and you want to shut this down, but she promised me she'd say a little more about who funds this campaign and why the person's doing it. I'd be interested. And I didn't want to say anything negative, and it just occurred to me.
He's, and Chris is about him. His name is Alistair McTaggart. He's a developer in San Francisco. And he has little kids. That's actually how we met, through our kids. And he was at a cocktail party with a Google engineer, and they were just talking. And so it was a couple years ago, and Alistair said to him, all this privacy stuff, should I really be worried about it? And the guy looked at him and said, oh, if you only knew how much we knew about you, you wouldn't be able to sleep. And so here we are, 2 years later with an initial.
All right, we'll have to see where this goes come November. But thank you, everyone. Thank you all for being here. Thanks to our panel as well. It keeps on the way out.
How much is it?
I mean, well, right now it's $2 million.